5 seconds to go. Start. The relied upon order had been suffering from failure on the part of the High Court to notice the relevant considerations, and the impugned order equally suffers from the shortcoming that the relevant features of the case have not at all been considered by the High Court. The submissions that the respondent number 2 had been in custody since 2nd September 2019, or that he had no negative antecedents by themselves, do not make out a case for grant of bail looking to the seriousness of crime in question. In this regard, the submissions of the investigating officer cannot go unnoticed that while the incident took place on 10th July 2019 and one of the accused persons was arrested on 11th July 2019, the other accused persons remained absconding and the respondent number 2 surrendered as late as on 2nd September 2019. So far, the questions relating to the role assigned to the respondent number 2 or about the doubt on the prosecution case suffice it to observe at the present stage that the respondent number 2 has specifically been named in the FIR as one of the assailants, and looking to the nature of the accusations and the nature of the injuries, the prosecution case prima facie cannot dubbed as fanciful or improbable. For what has been noticed herein above, the impugned order is required to be set aside. We have pondered over the question as to the order that needs to be passed in this matter finally. It is noticed that in the judgment and order dated 15th March 2021, this court disapproved the order dated 15th February 2020 granting bail to the co-accused and directed him to surrender forthwith. More or less, the same position would apply to the present case too. Herein, the order granting bail was passed on 3rd December 2020 and the present matter was initially taken up for consideration on 12th July 2021. Even if one witness, that is, the present appellant, has already been examined, the other witnesses, including the eyewitnesses, are to be examined in the trial. In the given circumstances and in the interest of justice, we also deem it proper to leave it open for the respondent number 2 to apply for bail afresh after surrendering and at an appropriate stage. Accordingly, and in view of above, this appeal is allowed. The impugned order dated 3rd December 2020 is set aside with the requirement that the respondent number 2 shall surrender forthwith. In the interest of justice, it is provided that if the respondent number 2 applies for bail afresh after surrendering and at an appropriate stage, such an application may be considered on its own merits. In the interest of justice, it is also made clear that we have not pronounced on the merits of the case either way, and none of the observations herein by itself would operate prejudicial to the interests of the parties, nor shall have any bearing on the final verdict by the trial court. All pending applications also stand disposed of. Stop.